Hello and welcome to the El Paso Elder Care channel. I'm Stephanie Townsend Ayala, elder law attorney and your video host for the channel. Today I'm speaking with Jennifer Coulter, elder law attorney and my dear friend, and we're talking about Medicaid and the Medicaid Estate Recovery Program. It's something that's kept a lot of people from getting the Medicaid benefits that they're owed. Jennifer, explain what the program is.
Medicaid Estate Recovery Program. It's sometimes called MERP. It's a program that was set up, required by the federal government, and then set up state by state to try to recover from the assets of certain people who get Medicaid benefits. It's been a big, scary boogeyman of Medicaid that often causes people to refuse to get the benefits that they need because they're required to sign a form saying, if you get Medicaid benefits, you agree to subject your estate to the Medicaid Estate Recovery Program.
And people with a limited understanding of English, or maybe people with a maybe limited education, in looking at that would not know that they could go get an attorney or that they could take it and appeal those processes.
It's not even just people with those kinds of barriers. The program's notices are not clear about how the program works, what it can and cannot recover, what the options are, and the people who have to give that paperwork to individuals applying are prevented by their agency's rules from being able to explain the program in more detail. And even when they can, they aren't attorneys, and the concepts in it are complicated legal concepts that are unfamiliar to most people.
So what is the program? Explain the program for us.
So how it works is this. For people who are over a certain age when they start to receive Medicaid benefits, who begin to receive them after 2005 for certain types of programs, mostly the ones that are affected by this are people who are getting nursing care facility or in-home care through Medicaid. Those kinds of people agree that they will subject their probate estate to the Medicaid Estate Recovery Program. The problem is, what is your probate estate? What does that mean? And for most people, we don't know. But what your probate estate is the part of your estate that we have to take your will to court to get transferred. For most people who are getting Medicaid benefits, that's going to end up being your house. The way most people take ownership of their house is outright. So I own it, and when I die, my estate owns it. It's very unlike, say, a bank account or life insurance policy, where when you buy it, they ask you, do you want to name a beneficiary? And if you say yes, and you name a beneficiary, your beneficiary has access to that account when you die automatically, not as a result of probating your estate. Those are non-probate assets. They are not subject to the Medicaid Estate Recovery Program. So for most people, the asset that they own when they pass away that is subject to this program is the home. So there's a big misconception that the state is putting a lien on your homestead and they are going to take that homestead away from you.
So let's get rid of some of those misconceptions. Now one of the things we do together is to help people avoid MERP. What are some of the ways that we do that to help people?
Well, with good planning, what we can do if we have the ability to meet with the person who's receiving the Medicaid benefits, or if that person's not able to handle things on their own, they're a power of attorney or guardian. We meet with them and we plan, how do we turn that probate asset, the home, into a non-probate asset, like a bank account with a beneficiary designation. The way we do that in Texas is through a really special kind of deed called a ladybird deed, or enhanced life estate deed. What that deed does is say, I, Jennifer Coulter, retain ownership of my house for the rest of my life. But when I die, it passes automatically to whomever I've named in this deed. You retain all of the rights. So even if I did that deed, I could still sell my home without anybody's consent. I could mortgage it, lease it, do whatever I want, including change my mind about who I've named as the beneficiaries. So the ladybird deed, if we have good planning, that's the way we go. It's very important to know that we don't just do it through a regular deed, because that is going to trigger all kinds of Medicaid problems. So the ladybird deed, that is the during lifetime option. But even after a person passes away and the Medicaid Estate Recovery Program says, we have a claim, we paid out $100,000 for this person's Medicaid benefits during their lifetime, we want you to pay it back. It doesn't necessarily always mean that we have to. There are statutory exemptions to it. If you have a surviving spouse, the Medicaid Estate Recovery Program can take nothing. If there's an adult child who lives in that home who's unmarried and who's been living in that home for at least a year, that way we can always get an exemption. An adult disabled child, there are even hardship exemptions in Texas. And those say for people whose income is under a certain amount, we can get rid of that claim. And then there is right now an exception that's called other compelling reasons, where they say, give us some good reason we should consider not pursuing this claim. And where we can do that, we can still get rid of it. But good planning, always the best, easiest, most efficient way to do it.
What's one of the biggest myths about the program?
I think that one of the biggest myths, I think there are two that are equal. One is it applies to every Medicaid program, and that's simply not true. We have 43 or 45 Medicaid programs in the state of Texas, and this program does not apply to all of them. A lot of people get regular Medicaid benefits that cover doctor's appointments and prescription and other things like that comes with SSI, and that program is not a part of this. But the major one that I see coming into my office at least a couple of times a week is my mom won't get benefits because she's afraid that if she does, the state is going to kick down her door and take her out of her home and take her home away. That they're going to put a lien on her home and take it from her. That if she goes to the nursing facility, they're going to take her home away. And where will she come home to? And that's simply not the case.
So how do you dispel some of these myths? I mean, because it's so ingrained. I know people walk in and say, oh, there's no way I can get Medicaid. Nope, don't want to lose a home. I'm not going to do this. How do you help overcome that huge barrier?
I have been spending a lot of time talking to people about the program. So I try to talk to people first, my clients. Second, I do a lot of speaking around town to try to tell people. But I also try to go to the nursing facilities and educate them because they also aren't lawyers. They don't know necessarily how these programs work. And so a lot of times I get people who come in and say, well, the nursing home told me I have to sell the house. Or the state's going to take it. I have to sell it or I can't get benefits. And so I spend a lot of time trying to educate people, nursing homes and clients and the populace in general. I also try to talk to the caseworkers at the administrative agencies about it because they don't know either. They are prohibited by their rules from explaining how this, or explaining at least how to avoid it, that it is an avoidable program. But a lot of misconceptions that they have affect how other people see the program. So I've been trying to do a lot of education, but there's a lot more that needs to be done. It's wonderful when I hear my clients say, you know, I was at the facility visiting my mom the other day, and I heard some other people talking about MERP and how afraid they were. And I told them, this is avoidable. And then I handed them the handout that you gave me. That's always one of my favorite things because I know that that message is getting out there. This is an avoidable program. This is something that nobody should be paying into if there's any ability to do planning.
Great. We're going to take a quick break. We're talking today with attorney Jennifer Coulter. We will be right back. We are back with Jennifer Coulter, elder law attorney and dear friend of mine. Jennifer, thanks a lot. This is so fascinating. Now, what about the Medicaid? If I'm getting Medicaid and I have a disabled child who's also getting Medicaid, and if I want to leave them the home, I don't want to knock them off their benefits. What do I do then?
That's an excellent question. This is a good question for anyone who has a child with special needs, regardless of that child's age. What happens is we see a lot of people writing kids out of the will. We don't want to affect the kids' benefits. We don't want to disqualify them. So we'll see people who write the children out of the will. What we can do instead is set up a really particular kind of trust, either during the lifetime of the parent or sibling, whoever's taking care of that person with special needs. Or we can set it up in their will. And what this trust does is say, the person who am making this gift, so I, usually mom and dad give to my special needs child in trust. And that trust's purpose is going to be to hold funds for the benefit of that child with special needs in such a way that those resources don't count against that child's $2,000 resource limitation. So we won't disqualify them from their benefits. And the great thing about doing it that way is that that money can be used for pretty much any need that the child has. We can use it for almost anything, for otherwise not covered medical services. So we can use it to supplement in-home care. We can use it to pay for clothing, for education, for entertainment, for travel, for pretty much whatever we want. And as long as we operate that trust properly, we're not going to disqualify the person from benefits.
So they can be receiving their Social Security check, their Medicaid benefits, and still have a pot of money set aside to help them in times of need.
Mm-hmm.
And we've used Special Needs Trust in our practice to help clients purchase homes. We've done vacations. We've helped clients get special equipment for their children, all kinds of things. So I know a lot of parents with special needs children have been told, hey, don't leave them anything, cut them out of your will.
Don't leave them anything. Yes, it's a big thing that has been told to those kinds of parents. And it's a terrible thing to tell them because there's this really easy solution to it. A lot of lawyers are afraid to tell them, leave it in trust because of trust taxation rules. And those trust taxation rules come at a compressed rate, which means we hit the highest tax bracket really, really fast. What they aren't taking into consideration is it's only for the income that's produced by the trust, and that income can be distributed out to the beneficiary every year so that we aren't triggering those kinds of tax consequences that cause the problems. Where we're not triggering those tax consequences, there's no good reason to fail to set up this trust that will help that child, that will provide for their needs. For a lot of people, we're looking at not disqualifying them from a benefit that gets them $730 a month. And we're saying, don't set up a trust and put $100,000 or $200,000 in it so that those kids can have the ability to do more than what $730 a month can buy. $730 a month, we all know, is not enough to buy a lot of the things that they need. So that nice clothing, that's tough to do on $730 a month. Any kind of travel, practically impossible on that amount of money. So there's a lot of stuff that we can do with it that otherwise is not going to be able to be done if we just write them out entirely.
So tell me how it works. How does the Special Needs Trust work?
Well, there's two basic kinds of special needs trusts. There's the kind that you and I have been talking about just now, where a third party, a parent, a sibling, a grandparent, whoever it is, says, I want to earmark some funds for my disabled child, for this disabled family member. So they set it up and they say, we are creating this trust and we're going to fund it with our own money. And those kinds of trusts get set up. We get a family member, if there's a family member we trust who's willing to do it, to be the trustee, or we can set it up with a corporate trustee if that's more appropriate under the circumstances. And that trustee makes distributions either to the disabled person or on behalf of that disabled person. We provide that trust information to Health and Human Services or Social Security Administration, whatever government agency needs it, so that they can be sure this is a third-party settled special needs trust. The other kind is what's called a self-settled special needs trust. So we sometimes hit the circumstance where we have a family member who did not get the advice to write the disabled person out of the will, but they also didn't get the good advice to create that trust in the will. So now we've given that gift outright to the disabled person. And now our disabled beneficiary has $100,000 that disqualify them from their benefits. What we can do with that, as long as the person is under 65, is create one of these self-settled special needs trusts.
How does that work?
The self-settled special needs trusts are a little differently. They have to be created by the parent, grandparent, or court for the disabled beneficiary, but with the disabled beneficiary's money. So I, as a disabled person, get $100,000. I am hopefully clearly under 65. Um, and so I say, Mom and Dad, I need you to go and create this trust for me. So they set up a trust. These trusts can then take my funds and hold them for me and use them for my benefits. They're going to have slightly more restrictive distribution standards. So now we may be able to use it for travel for me, but we can't pay for a companion to travel with me. So that's a little more restrictive and different. The major thing to know about these, though, and why I say let's set it up as a third party settled special needs trust in the will instead of just giving them the gift and letting them set it up themselves, is these kinds of trusts must have a Medicaid payback provision. If there's anything left in the trust at its termination, Medicaid gets paid back dollar for dollar. This is not a part of the Medicaid estate recovery program. It cannot be avoided. It just has to be done. So if we can get around doing it as a self-settled, if we can structure it to go as a third-party settled, that's what we want to do. But if we need to do it as a self-settled special needs trust, that is still significantly better than spending that $100,000 on the person's care and the benefits that on the things that the benefits would have otherwise covered until all of that's gone and getting the benefits back then.
Well, we're going to be wrapping up here, but what is your advice to parents with children with special needs?
My advice is go talk to a lawyer. Make sure that your estate plan is good and in place. Make sure that you're taking into account that you have a child with special needs. Be sure that you know what you're planning. I have a lot of people who come to me and they say, well, I don't really have anything to leave them. All we have is this house and they're going to live in the house forever and they're never going to sell it. And I say, well, that's good and it's wonderful. And I'm glad that they're going to have a safe place to live. But let's make sure that if we need to sell that house, even just to sell that house to buy a new one for them, we want to be able to know that that is doable. And it's not always easy to do with a disabled person. An incapacitated person may not have the ability to sell that house if it's in their name without court intervention. But if it's in the trust's name, the trustee can sell it for them. So even where we think, I don't know that I have an estate that warrants going and doing all this planning, it's important to know, go talk to the lawyer, make sure things are in place. Know that the best thing you can do for your loved one is ensure that you've planned for their future as well.
Thank you so much, Jennifer
Thank
Coulter, elder law attorney. This has been fun. Appreciate it.
Thank you for having me.
And thank you for watching the El Paso Elder Care channel. We'll see you again next time.